We're doing it again. We're back. We still have wisdom to impart.
We just keep coming back.
Lots of wisdom to impart on you.
So we focus a lot on estate planning and probate and personal, the everyday person kind of thing. But now I think we should focus on business owners.
Yes.
We have lots of small business owners, medium-sized business, large businesses. And they can all be handled slightly differently, but along the same lines when we talk about succession planning. Right. So there needs to be some sort of succession plan if you intend on making sure that your business outlives you.
100%. One of the things about creating a business is it doesn't die. So a person can die, the principal can die, but the business lives on in perpetuity until it's dissolved. And that's a wonderful thing that a company can survive even the death of one of the owners. However, it needs to be documented correctly, or otherwise it's not going to survive the probate process, whereby the owner's interest gets divided or sent to wherever it's supposed to be, because no one can act on the company's behalf during that period of time.
Yeah. And I think this falls into two problem areas that we should focus on.
Okay.
The first being no succession plan, right, and the second being the business not being set up correctly.
Sure.
Okay. So I think for purposes of this session, we should focus on limited liability companies, whether they're taxes, partnerships, or corporations, as an S-Corp, or sole proprietors.
Yes.
I think we should focus on that. We'll leave corporations kind of out there on their own for now.
For sure.
So the first issue is, was the business set up correctly with the proper documentation? The second is, if it was or wasn't, did you have a succession plan in place?
Right.
And if you didn't have the former, you probably don't have the latter, but it's possible.
Correct.
And it's more so possible with sole proprietors.
Yes.
Right? I started this Etsy business. I started this carpet cleaning business. I started this tiling, plumbing. I don't care what it is. You started this business and it was just you.
I started this business and it's just a hold of real estate for a rental property I have. It's just
Whatever
me.
it is.
Right.
Yep. And so if we focus on the first, let's focus on the first set of issues of not having proper documentation. If you don't set forth who actually owns the company, now we have to look at your taxes to prove ownership, and that's all we can do. Right. There's no other way that we can, maybe you registered it with the Secretary of State, and that will prove maybe a manager, maybe it will prove a member, but it just depends on how you set it up.
And that goes to a great point. People set up their company with a Secretary of State, and it's fairly easy. It's just go through a process, but they don't understand the implications of different people or different options. So one of the main things is the company member managed or is it manager managed?
Yeah, if we're talking about a limited liability company, do we want it member managed or manager managed? And that is a business decision.
Right.
But if you pick the wrong option, it could impact future dealings, particularly if it's member managed.
100%.
And so, especially if you have no documents reflecting who the manager is or who those members are. Now, how do we know what percentage they own? How do we know any of these things?
Right. And who has the authority to appoint a manager? Who has the authority to sign on the bank account? Who has the authority to sign contracts, to pay bills?
Exactly.
All that should be in the operating agreement that says who has those abilities, who can do this.
Right. Or a partnership agreement or whatever agreement you have. It should be an agreement setting forth these expectations.
Correct.
We're talking about member manager, and those terms are unique usually to limited liability companies, but you have partners, you have shareholders if you're talking about corporations. But again, as we were stating, this is going to focus mostly on limited liability companies.
Right.
So when we're starting to talk about that and we don't have these documents in place to say what happens, that kind of puts us into the second issue of what happens when somebody passes away. Well, we didn't have anything previously what said what happened, so we probably don't have anything afterward that says what happens.
Correctly.
And so what happens if there are no documents?
If there are no documents, then you have to piece together who is the owner. And like you mentioned before, you look at the tax returns. Who paid taxes on the profits or the losses for this business? What percentage did they put on their tax return? Who else put the percentage on their tax returns? Now, potentially that will prove that it was all 100% one person. Okay, so they own all of the shares of this company. Well, if they pass away, then this company, and some will say, the company can't continue anyway because I was the one doing all the work. But there's still maybe contracts outstanding.
You have receivables.
There's bills outstanding.
You need to
You're
pay bills.
owed
Exactly.
money. So there's still things that will have to happen, even just to wind up the company, that unless you have something in place, there's no one that can actually do that on your behalf.
Right. And even if it is the business is you, I don't care if you're a CPA, I don't care if you're an attorney, I don't care if you're a plumber, a tiler, a roofer, whatever it is, there are supplies that go into that profession, whatever it is. So if you intend on selling those, right, that's a business and you have no authority to do it if there is no documents put in place to sell this.
No one can sign on behalf of the company unless you can prove that you're the member or the manager, depending on what you decided how the company was managed.
Exactly.
And so if no one can sign on that behalf, then we're in court.
Not only are we in court, but the business is failing.
Well, the business can't survive because they're not going to be able to survive the time period it takes to get some sort of court order.
Exactly. And so if you listen to our probate podcast, you would have heard us say about the time frame of these things. And usually you can get somebody appointed on behalf of the estate within a month of having all the documents, but getting all the documents in itself can take a couple months. So best case scenario, you're probably about 3 months out to even being able to run a business. And having no owner on a business for 3 months is detrimental.
Right.
I don't know many businesses that can survive for 3 months without an owner being able to do everything that they need to do, whether it pay bills, sign contracts, receive any of it.
Correct. And we'll often hear, oh, well, there's 2 of us on the bank account. So if I pass away, they can still, pay the bills. They can still, but can they sign contracts? Do they have ability to sell all of the assets of the company? No. And a lot of times people feel that their company or what they've built is one of their largest assets of their estate. And if you have the ability to sell it or have the ability to do something with it after you pass away, then it won't survive the period of time. And then it's not going to be worth anything. Your heirs aren't going to get anything unless there's provisions put in place beforehand.
Yes, and I will tell you a profession that comes up a lot, and not just a single profession, but any profession that involves a contractor. So I need to have a contractor's license. I need to be the key employee that holds this license. A lot of the time you have this business owner that isn't necessarily the business owner, but they started the business, they grew the business. They just weren't the contractor, so they're not that key employee. So they pass, or the key employee passes away.
Right.
And that person is like, but it's my business. I'm the one that built this. I'm the one. Prove it.
Yeah.
How are you proving this? The main person that had the licensing, that was doing all of this stuff is gone.
Right.
Now what?
Well, that brings up another point. You can make a professional limited liability company, which you have to be licensed in certain fields. So that's your doctors, that's your attorneys, that's your CPAs. So you have a professional license. You want to create an LLC to protect yourself from liabilities. So you create a professional limited liability company. You can have other professionals that have that same license. Both of you can own it together, or it can just be whoever has that license. But if something happens to you, there needs to be something put in place, like who's going to see your clients? Who is going to be the ones that make sure your employees are paid? I mean, all that needs to be set up beforehand, because it can't just be your heirs because they don't have that professional license.
Right. And even if we take it one step removed of not having a professional license, but they just don't have the knowledge to run the business.
Fair.
Regardless of it being professional or not, if you put me into a farm, I'm not going to be great.
Right.
I'm not a farming heir. Don't ask me, because I can't do it.
Right.
But if now I'm the one that's stepping into this farming business, the other people that own it don't want me there.
Right.
What am I doing there? But because you didn't have the documents in place, now that I don't want to be bought out. Let's say I'm one of the heirs. I don't want to be bought out. I want to help run this business. And the other people are, we don't want you here.
Right.
Well, then that should have been in the operating agreement or the buy-sell agreement that we had that talked about that.
100%. When you go into business with someone, it's a big leap of faith. You are putting a lot of your success with this other person. And that's why you have the operating agreement that spells out what you want, what They want what the expectations are, what happens if it goes bad, or if we want to part ways. It all is spelled out in that operating
Or if one of us dies.
Or if one of us dies, because we want to be in business together. I don't want to be in business with your heirs or be forced to be in business with your heirs.
I don't want your spouse stepping into this. I wanted you. And now that you're not here, I don't want anyone.
Exactly.
And so do we have, and this goes into, do you have that key man policy? Do you have insurance policies to make sure you can buy out heirs? Do you have all of that? But again, if you don't have the original documentation saying what happens, none of the rest matters because you have no instruction on what to do.
Right.
And again, that's the first problem.
Right.
It's just not having this instruction. The second problem that we'll talk about is even if you have those documents in place, if it's owned by you as an individual, you're still in probate.
Exactly. If you own anything individually and you don't have it in a trust or you don't have beneficiaries in place for it and you pass away, it is going to go through probate.
Yes. And no. Yes, because it legally should, because that was owned. But sometimes it doesn't, because sometimes they say, oh, it was a handshake deal. I'm just going to pay out your heirs and then I'll take their name off. And why is that a terrible idea?
That is a terrible idea because it leads to you're just exposed on so many levels for liability. Somebody else can come back and sue you. It's such a terrible idea that I'm surprised you even brought it up, because I was like, no, that is a terrible idea. You could never recommend somebody do that because there is just too much at stake. People could come back and sue you. There's too much liability out there.
It's illegal, number one. But aside from that, even if you as the individual want to bypass that of transferring it independent of any type of probate situation, you have tons of liability in doing that.
Tons of liability.
And so even if you could do it, probably shouldn't do it.
Right.
And so how do we go about, we've talked about how important operating agreements are. We've talked about how important succession planning is. But how do we actually achieve it? You're telling me even if I have this operating agreement, I still have to go through probate. Right. Can I avoid it?
So different states have different provisions. So in the state of Ohio, they'll let you put beneficiaries on your interest in LLCs. Now in Nevada, we don't have such a provision. So the best way is to have a trust, create a trust, own your membership in the LLC through your trust. So if something happens to you, then your successor trustee steps in and can make the proper ownership decisions of that operating agreement or of the company, whatever is
there. Right.
Right. Whatever you have to govern you.
Yes. Okay. So we put our interest in the trust. And the next question that we always get after that is, doesn't that expose my trust assets? If I put my business in my trust, doesn't it expose my trust assets? And the answer is no. It doesn't, because we're talking about two different levels of protection. We have an LLC that's protected insular from acts within the LLC. So if the issue becomes that somebody, let's say it's a rental house and I own a rental house.
Right.
I put it in an LLC, somebody trips and falls on the property. It can get to the assets that are held in the LLC.
100%.
But the trust isn't held in the LLC. The LLC is held in the trust.
Right.
Now, if we do the opposite, let's say somebody slips and falls in my primary residence that's owned by my trust but isn't owned by my LLC.
Correct.
They can still get to my trust, or they can still get to the LLC assets through a charging order, which is a very complicated process that most people wouldn't even bother doing. It's possible, though.
It's possible, but all they can do is get a charging order for your interest in the LLC. The same that they could do as if you held it as in your individual name.
Exactly. So there is no downfall of putting it into a trust anyway, because even if they can get a charging order, if you hadn't have put it in a trust, they could have done it anyway.
100%.
Exactly.
Yeah.
So if you're in Nevada or any other state that doesn't allow a beneficial interest on a membership interest or shares or whatever they may be, a trust is a really good route to go because there is essentially very few downsides of doing it, and you can avoid that probate process and allow the continuity of the business because the trustee is going to step in, or somebody you've designated within your trust is going to step in to help run that business until it can be sold, until you can, transfer it to somebody else, all of that thing.
100%.
Very good.
One thing we encourage people to do is do power of attorneys. And so if you set up a power of attorney, does that give you the ability to sign for the company? So say I am the manager of an LLC.
Mm-hmm.
I give you my power of attorney if something happens to me. So I'm in a coma. Can you act on my behalf on behalf of the company?
Well, it's going to be governed by the operating agreement on if it allows it, but also the power of attorney is going to specify what you can and can't do. So you need to make sure that all of your documents are congruent and say the same things, number one. But number two, you would have to make that election of whether they can or can't do that when you actually complete the power of attorney.
And you could do a special power of attorney, just
A limited one, yeah.
a limited one, just with regards to that operating agreement. So
Or a
if there's-
transaction.
100%. So if you're going to be out of town, there's a big sale coming up, you can give another manager, you can give somebody else the ability to sign on your name through power of attorney for that agreement, for that deal, for that period of time. You don't have to give it universally.
Exactly.
So that's an option, even if you have a separate power of attorney that gives somebody more general power of attorney to carry on your banking things outside
IRS.
that LLC. That's 100% correct. And then the other important thing to know is as soon as you pass away, the power of attorney no longer works.
Right. And so lots of people will come to us with the powers of attorney and say, can't I just use this? Look, I have the power. They gave me the power. The power only exists while they're alive.
Right.
They can't continue to give you that power if they've passed away.
Right.
And so as soon as somebody passes away, that power of attorney is done.
Right. If they don't have the ability to sign, you can't sign on their behalf.
Exactly.